If you are an immigrant, an international student, a professional on a work visa, or a family member waiting for green card approval, what happens in January 2026 could directly affect your future in the United States. The changes coming are significant. The timelines are shifting, and the costs are increasing. This is not speculation. These updates are happening, and the window to prepare is closing faster than most people realize. In this video, I am going to break down exactly what is changing, who will be affected most, and what you need to understand before these new rules take effect. Stay until the end, because the final point I share could save you months of delays and thousands of dollars. Before we get into the specifics, let me explain why January 2026 is becoming such a critical marker for the U.S. immigration system. Every few years, U.S. Citizenship and Immigration Services, along with the Department of Homeland Security and the State Department, implement major updates to fees, processing requirements, and application procedures. These changes often roll out in phases. But January 2026 represents a convergence point where several significant updates are scheduled to take effect simultaneously. This is not one small rule adjustment. This is a coordinated shift across multiple visa categories and immigration benefits. What makes this particularly important is that these changes will impact nearly every type of immigration case. Employment-based visas, family-sponsored petitions, adjustment of status applications, naturalization, and even asylum cases will all see modifications. Some of these changes are designed to modernize the system. Others are meant to increase revenue for USCIS. And a few are intended to address backlogs that have plagued the agency for years. But here is the reality that most people overlook. The immigration system does not give you a grace period. When a new fee structure takes effect on a specific date, applications received after that date must comply with the new requirements. If you submit the old fees, your application will be rejected. If you use outdated forms, your case will be returned. And in many situations, that delay can cost you your status or your place in line. Let me walk you through the major changes you need to understand. The first and most immediate change involves filing fees. USCIS has announced a restructured fee schedule that will take effect in early 2026. For many applicants, this means substantial increases. The I-485 adjustment of status application, which is the form used to apply for a green card while inside the United States, will see a fee increase that could exceed several $100s depending on your category. Naturalization applications through Form N-400 are also affected. Employment authorization documents, travel permits, and petition filings will all carry higher costs. But this is where many applicants go wrong. They assume they have time to save up for these fees. They wait. They delay gathering documents. And by the time they are ready to file, the new fees have already taken effect, and their budget is no longer sufficient. If you are planning to file any immigration application in the next several months, you need to calculate whether it makes financial sense to submit before the January deadline. The second major change involves biometrics and interview procedures. USCIS has been piloting new systems for identity verification and case processing. Beginning in 2026, certain applicants will be required to complete biometrics appointments using updated technology, including enhanced digital fingerprinting and, in some cases, facial recognition verification. While this is intended to speed up processing and reduce fraud, it also means that applicants who miss or delay their biometrics appointments may face longer wait times. There is also a shift happening with interview requirements. Certain categories that previously required in-person interviews may see those requirements waived under specific conditions. Conversely, other categories that had relaxed interview policies during the pandemic era are returning to mandatory interviews. This inconsistency is causing confusion. Later in this video, I will explain how to determine whether your case is likely to require an interview under the new guidelines. Now let me address something that does not get enough attention: form updates. USCIS regularly revises its forms. Sometimes the changes are minor, such as updated edition dates. Other times the changes are substantial, with new questions, additional documentation requirements, and modified instructions. In 2026, several commonly used forms are scheduled for revision. This includes the I-130 petition for alien relatives, the I-140 immigrant petition for employment, and the I-765 application for employment authorization. Here is what you must understand. If you submit an outdated form after the new version becomes mandatory, your entire application will be rejected. You will not receive a request for correction. You will not be given an opportunity to update it. Your filing fees may or may not be refunded depending on how the rejection is processed, and you will have to start over, potentially under the new fee structure. This is one of the most common and entirely avoidable mistakes in the immigration process. Always verify the form edition date before submitting anything. Check the USCIS website on the day you plan to mail your application. Do not rely on forms you downloaded weeks or months earlier. Who will be affected most by these changes? The answer is almost everyone, but some groups will feel the impact more acutely than others. Employment-based green card applicants, particularly those in the EB2 and EB3 categories, will be affected by both fee increases and processing changes. If you have a pending I-140 and are waiting to file your I-485, the timing of your adjustment application could determine whether you pay the current fees or the new higher fees. Family-based petitioners, especially those sponsoring spouses, parents, or children from abroad, will face updated requirements for affidavits of support and financial documentation. The income thresholds used to calculate whether a sponsor meets the financial requirements are also being adjusted. If you are close to the minimum income line, you may need to secure a joint sponsor or provide additional evidence of assets. International students on F1 visas who are applying for optional practical training or transitioning to H-1B status should pay close attention. The H-1B registration process has already seen modifications in recent years, and additional changes are being implemented to address fraud and system abuse. If you are planning to enter the H-1B lottery in 2026, the rules you followed in previous years may no longer apply. Asylum seekers and humanitarian applicants will also see changes, particularly in how work authorization is handled during pending cases. Processing priorities are shifting, and certain categories may experience longer wait times while others are expedited. Understanding where your case falls in the priority order is essential for managing expectations. What happens if you ignore these changes? The consequences vary depending on your situation, but none of them are minor. If you file with incorrect fees, your application is rejected and returned. You lose the time it took for USCIS to receive and process the rejection. If your status depends on a pending application, that gap could leave you without valid status. If you miss the deadline to file under current rules and your fees increase by several $100s, you may need to delay your application further while you gather additional funds. That delay can affect your priority date, your work authorization, and your ability to travel. If you submit an outdated form, you face rejection and the need to refile, potentially with updated evidence and certainly with frustration. And if you fail to attend a biometrics appointment under the new system, your case can be delayed or even denied for abandonment. So what should you do? First, conduct a full review of your immigration situation right now. Identify any applications you are planning to file in the next 6 to 12 months. Calculate the current fees and compare them to the announced fee increases. Determine whether it makes sense to file before January 2026. Second, verify that all forms you intend to use are the most current versions. Bookmark the USCIS Forms page and check it regularly. Do not assume the form you downloaded last month is still valid. Third, if you have a pending case, monitor your case status for biometrics appointments and interview notices. Respond promptly to every request. Do not assume that delays on the government's side give you permission to delay on your side. Fourth, stay informed. The immigration system changes frequently, and what is true today may not be true in 3 months. Reliable information is your most valuable tool in this process. I want to be clear, I am not providing legal advice. Every immigration case is different, and the right decision for one person may not be the right decision for another. If you are unsure about how these changes affect your specific situation, consult with a qualified immigration attorney who can review your case in detail. Let me summarize the key points from this video. 1. Significant immigration changes are taking effect in January 2026, including fee increases, form updates, and biometrics modifications. 2. The window to file under current rules is narrowing. If you are planning to submit an application in the coming months, evaluate whether filing sooner could benefit you. 3. Outdated forms and incorrect fees are among the most common reasons for application rejection. Always verify before you submit. 4. Different visa categories will be affected in different ways. Understand where your case fits and plan accordingly. If you found this information helpful, consider subscribing to this channel. I cover immigration updates, policy changes, and practical guidance to help you navigate the U.S. immigration system with clarity and confidence. In my next video, I will be breaking down the step-by-step process for filing adjustment of status under the new 2026 rules, including the documents you need and the mistakes you must avoid. Thank you for watching. Stay informed, stay prepared, and I will see you in the next one.